So I've been getting a lot of questions lately about airdrops and bounties and whether there's legal issues that surround both. And of course, obviously there is with anything, but let's assume the worst case scenario. And if you want to take that from the perspective of all of these ICO tokens being securities, then what do? Like, are you engaging in an offering of securities, and is there a proper exemption if you're doing like a bounty? And there is, in theory. Rule 701 says that pursuant to a written agreement, an issuer can issue securities in exchange for services, right? And that can extend to consultants and advisors. So you think about like the pure startup scenario where you have a bunch of like kids working for you and you pay them in stock, right? I myself accept stock all the time, right? It's just sort of the way that you are compensated when you work with early stage ventures, as I take token, right? So it's kind of a common way to do it, and the 701 exemption is used repeatedly, and so you could apply that to airdrops and bounties, and I think there's some nuance to it. 701 requires a written agreement. So that written agreement doesn't necessarily have to be a signed sort of counterparty wet signature agreement, but you have to have some sort of writing that evidences what compensation you're receiving in exchange for doing a certain service. So in this case, even something I think as simple as like your Bitcoin talk announcement thread would be sufficient. Two, the services have to be not related to raising money, right? And so when you think about like the utility token context, and I think this is really important, what you have to be very like certain of and very clear about in your announcements and how the bounties run is that the sort of promotion, the social media, whatever people are doing to earn these tokens are doing it to promote a product or service as opposed to promoting the ICO, promoting the sale of that token, right? So it's very, very clear under the law that it can't be for fundraising. So likely in the way most of these go, your social media promotion, something like that, is really just promoting whatever network or platform you're creating. And finally, especially in the context of a consultant or advisor, which all of your bounty and airdrop participants are ultimately going to be, right? That's really what they are, as consultants or advisors, just on these very small micro transactions, is that they can't be engaged in any sort of securities promotion, right? And this is sort of like a relic of the penny stock days where you would pay penny stock promoters to go out and like promote the stock, but you pay them in stock. Well, they closed that loophole. So again, going back to point two, your consultants and advisors, e.g. the participants in your bounty, have to be very, very careful that they're not promoting anything that's particular to the issuance of these ICO tokens or the offering of these ICO tokens, right? And again, we're coming from the perspective that all the ICO tokens are securities, which I don't believe they are. But in a worst case scenario, are you able to do it? And retroactively, if someone came in and said this token was in fact a security, was it in fact legal to do the airdrop or the bounty? And I think it is under Rule 701. And from what I've been able to ascertain, both in my own involvement and in the involvement from other attorneys I've spoken to, it doesn't look like there's really to date been any action by the SEC that has focused on or even really paid attention to like a bounty program or an airdrop as it relates to the issuance of tokens. It's been more focused on sort of the ICO concept and what's that. But it is something to think about, when you're designing these, like what you're actually paying people to do and what, especially if it's social media marketing, what they're actually promoting, right? It has to be focused in an overwhelming part on the utility, right? But again, that's the focus of these things. That's the focus. That's how you have to approach these. Your marketing in general needs to be on the utility, not on the offering or the upside potential, price appreciation of your token. So check me out, as usual, bitcoin-lawyer.org. Not a nonprofit, but very close to it. I'm Adam Tracy. I'll talk to you soon.